back. Thanks for staying with us. Planet Green Trees 1-347-326-9626. What's wrong? All right, so I'm going to go to our first caller here. I think we got our friend Rick Thompson, I think. Is that you?
It's true.
All right. Rick Thompson, of course, the editor-in-chief of the Compassion Chronicles, chronicling compassion in the medical cannabis community and many other things. Rick, welcome to the show.
You know, Michael, we talked about 2009 and 2010, pre-raid time, what we were experiencing, what we were thinking. I think that at that time we pretty much figured we had a good handle on this. It was brand new. We'd all read it over thoroughly, and I didn't think we figured there were as many great as people like.
I agree with you. I did not. I mean, we know that because the gray areas have been, whatever. I don't use that word as my description, but what was called gray areas, and there's been a lot of clarity that's been brought to us. But still, the things that were said to be gray turned out not to be gray. Like whether you had a defense or not is not gray. The whether you can mention medical marijuana in court is not gray, and it goes on and on and on. But I mean, that the patient can drive with cannabis in their system and not be intoxicated, it's not great. So, but these things were for a long time. And it's frustrating because, first read, very clear,
Yeah, that's in Chapter 2 when the Court of Appeals had its way with us for a while.
Right. But, Rick, let's go back to you, and I want to go around the room. Jamie had some comments. I think we can even ask David can chime in and Chad because, just forget, the people, but just like the view of it, like what you saw. I mean, just give us your thoughts, Rick. What remember, think back at that 2009, where you thought it was going and why.
Well, the Michigan Medical Marijuana Magazine back in 2009, and we were full of hope and promise for new businesses of all kinds starting up across the state. Patients had a newfound freedom. It was a time of, like I say, hope and promise. We really did believe that we understood what was going on, what the parameters were. And although there may have been some people that began businesses with false assumptions or with incorrect intentions, most everybody that was involved in at that time really looked forward to a brand new career. 2009, 2010, a lot of people quit their regular jobs to become full-time caregivers. A lot of people invested their life savings into brand new businesses, whether it be hydroponic shops or head shops or distribution centers or services. It was really not necessarily a wild west, but it was a renaissance. People of this community. That's what I remember about that time, and that's what made those raids in 2010 the more hurtful pain because it popped our bubble to a bit.
I like that there, your renaissance. I'm going to relabel this part one, the renaissance. I agree with you. It was, there was a lot of excitement. I think naivety is a word that comes to mind, but the naivety is based upon, it
was based upon Cox taking a hands-off approach to the proliferation of medical marijuana businesses.
And also, there's this, it's not even fair to call it naive because I think it's fair to say that most people should believe that when they vote for a law, it's going to be implemented in a way in which it was intended to, which was to be protective. This is a prophylactic law. It's supposed to have expansive protections. But it was resisted. Crazy things happened in the interpretation. Different communities rejected it and went wildfire, like just abandoning principles of law, abandoning principles of common sense.
Basic principles like the ability to defend oneself under assault.
And, that to me is the most, with all the optimism, you sense the institutions surrounding this change not willing to even acknowledge it in a lot of places. It goes back to the education. I think that at the very beginning, if there's one do-over or redo, it would be, to take $10 billion and rewire all the police officers in the state of Michigan to think that medical marijuana is a legitimate medicine. No, I'm just kidding. That would never happen. But some efforts to try to educate them and have them look at medical cannabis as a public health issue instead of a public safety issue. But that's not the case. I mean, Jamie, I want to hear your thoughts, but I know in the course of your activism over the years and the national activists that you've talked to and had this conversation like, well, what happened in your state when this thing first went on? There's a manifesto that's passed around amongst law enforcement of how to deal with an initiative passed for medical marijuana. What was it, Jamie? Tell us how that came to be in your experience with this in that way.
Well, we also found out that in each state there's a pattern of whatever their version of like the municipal league is gets targeted, and a lot of restrictive, kind of prohibitive policy and language and things like that come through there to the local governments that are seeking their advice, and they get to them early on, and that turned out to be part of the issue too. Of course, our experience was in a place where it was very well received by the community and heavily demonstrated by the way they voted it in. They were reasonable, as Rick mentioned, and as a lot of people read the act, they're very, very reasonable ways of interpreting the ability to kind of do what we started doing there. And now we think that we're at a point where we've established ourselves and demonstrated why that was a good idea, and we have a different set of things because of, later on we're talking about the beginning here. And so I think that turned out back then to be a good idea, and I still think it is, even though we have some obstacles. But that was our part of the situation in battling with the trend of opposition that's out there, and we saw that it happened throughout the country every time there's a medical marijuana state.
Interesting. And of course, I want to move on to David. You're next. I want to hear your thoughts from the Renaissance period of the medical marijuana. That's what we're calling it. That phase is post-ballot initiative and pre-raids, Renaissance. But Jamie brings up a very interesting point, which is one of the things that I would recognize during this Renaissance period is there was some individuals, not many, who were in early. What do I mean? I mean, they made good relations with local community and led with the education, and were somehow able to bridge the gap or the fear or whatever the knee-jerk prohibition mentality is, and seemingly get the discussion revolving around compassion and education and safe access and things like that. And as we look back now, there's few that remain across the state, and many of them are not like those that came late in the game. It's those that began at the beginning and had developed these relationships, said that they were going to act and be in a certain way, took accountability for how they were going to act and behave, and followed through on it, got past the initial concerns and became part of the local community where patients were receiving safe access and, the antithesis of what could be described as a nuisance, actually bringing business. And I say that because I obviously counseled with many people, and, my law practice changed because there were so many people that were seeking information and wanting to consult and get a gauge on what they can and cannot do. And, I always, believe that it's, in order to really be successful in those veins as things were developing, the key element was really to try to be welcomed by the local community. That's one of the approaches to take. Jamie, of course, was one of those people, and I mean, it's a testament to his many things, but the minimum, like how to do it right in the sense of.
Turns out it was the only approach to take, really.
Right. Everyone else is
down to it.
And still there, still within compliance of the law and working with the local community to try to resolve those things, despite some still political ambushes here and there. But David, you're on. What do you think? You remember back that time? You were just a little baby then, weren't you?
I was actually clerking for a circuit court judge.
Who?
Right when the Judge Rosemary Aquilina, 30th Circuit Court in Lansing.
Excellent.
I remember the first time she came up with, because basically what I would do for her is some motion would get filed and I would have to analyze the law. And there were a couple other interns doing the same thing. And I remember when the question of the MMA on probation came through her court. And I got in a big argument with her actually about this. But her conclusion was that, you know, it's a violation of federal law and she has to uphold all laws. And I said, you know, I mean, I don't think that state courts can enforce federal law. So, but, you know, I never wanted to fight with her too much because she was kind of my boss. But I feel like I don't know where this idea came from that she has the right to enforce federal law on that issue.
Yeah, let's look at the statistics of state court judges who have been prosecuted for following state law. Let's look at it right now. I mean, is that the fear here? Let's see how many have been referred to the Judicial Tenure Commission and had some kind of, you know, mark on their judicial tenure record. I mean, what is that?
You know, I just think that the question's being asked wrong. We have to ask to not be drug tested as opposed to asking them to approve medical marijuana use. Well, I think they're for some reason they're not willing to go on the record as approving medical marijuana use or something like that.
What Chad's trying to say is this: a judge who's trying to do right, whether you like him or don't, her, him, whatever, you know, they have to answer its political position. So when every jurisdiction thinks of it differently. In different jurisdictions, police forces, what have you, probation departments are having, you know, are not dealing with it in the right way because it's not medical issues. But the point is being made is that there's two different types of requests we're talking about. We're talking for asking the court, the judge, him or her, to approve of your use of medical cannabis. To say yes, enforce. We enforce that and suggest and agree. I mean, embrace the medical decision by your doctor and support your medical use. I think some judges, I learned early on, a lot of the judges aren't comfortable with this, not because of medical cannabis, but that they don't really understand the concepts of the caregiver. They don't really understand how a patient gets their medicine. That if they're approving of it, how does a judge who's approved of it, you know, get involved in you, a patient, potentially going to a place and trying to get it that in their mind may not be safe. See what I'm saying? I heard one judge talk about that, the availability, like if they're approving of it, I'm just telling you, I'm not making excuses for them. I'm just telling you some of the crazy things that came out. But the suggestion that's being made here is that it's easier to rule that no testing be done. It's less of a sanctioning per se, and sometimes judges may be more inclined to allow for that when they don't see it necessary to test. Nevertheless, David Rudoi, any thoughts on that? Finish your thought on the...
I want to interject a little bit what David said before, though. That federal thing is common. It comes from that misinformation that's perpetuated through like the municipal leagues and through anybody who's willing to take it and get it to the people who are in the position to implement that stuff. It happens in every state. They use the federal argument. Obviously, it went through the Federal Court of Appeals in California and won, and then it was decided. Then it was not picked up by the Supreme Court. So it's always part of the strategy against us.
You know, I remember that was a huge discussion at the time. Federal preemption and how some of these courts or judges drew the conclusion, well, I'm just going to say that it's, you know, I'm just going to say that it's illegal federally and that's going to let me off the hook. And this isn't true because I just pulled out a brief from back then, and got this. The Controlled Substance Act expressly provides for federal preemption of state drug laws only where there is a positive conflict such that the two sets of laws cannot stand together. And the idea here is that if Congress included in the Controlled Substance Act, they did not specifically express a provision which contains an unambiguous expression of intent to preempt state law from creating a medical marijuana law. That's how this is argued. The point being that it's a false argument. The idea is this, that for someone using their marijuana, pinpoint to me in the Controlled Substance Act the exact statute by which an individual would be in violation of the Controlled Substance Act for using medical marijuana. Does it exist? See what I'm saying? Like the use of it, how does it really violate federal law? The use of it medically, it's not specifically prohibited. I'm arguing. Nevertheless, forget that. But what did she do? Did she write in returning to your judge?
I mean, that was the policy of the entire 30th Circuit Court. I think at some point she got together with the other judges and made up that as far as the probation violation, and that's how she, I'm sure, continues to handle it.
You raised an important point. I know we got our callers on the phone. We're going to get right to you. And Jamie, if you want to get in again for a second. That was the policy of the judges in the 30th Circuit Court. Is that what you're talking about?
Yeah.
Well, that's my point. They may not even come up with it themselves. They may have consulted with the probation department on how difficult it's going to be to manage, or how they're going to lose all this money because they're not going to be able to test, or something like that, or all this. There's different reasons. And David's point I wanted to emphasize in that this is the way. These are the institutions that I'm talking about that have been, they've created certain compartments for different, alleged crimes. When they come into the court, where they're going to put them, they're going to be stuffed into a certain place, and money's going to be taken in activities and requirements in order. But this medical marijuana is a paradigm change, and they've tried to fit it into the previously existing compartments when it's its own animal.
Well, one thing I'll say about the judges, I mean, I do think when the community comes out in strong support of medical marijuana, and the judges know that. I mean, I was in Ferndale this week. I had a really good experience. Judge Longo, I wasn't on the representing anybody at the time. I was just watching, and a guy, unrepresented, possession of marijuana charge, and the judge says, let me ask you, do you have a problem? And the guy goes, what? And he's like, do you have a problem? I think that you can use marijuana recreationally. Some people go home after a long day of work and have a couple beers. Some people go home and have a joint. But you can have some people also have a problem with it, and if you have a problem with it, I'll help you. But otherwise, we don't need to. And gave the guy just a fine on a possession of marijuana charge because the guy said, no, I use it recreationally.
That same judge also did not discontinue the ability for the defendants in the clinical relief case to use their medicine. He says, I'm not the doctor.
Yep.
Same judge.
Judge Longo.
Yeah. He is definitely a supporter. I think he reflects the will of his community, and I think that other communities need to take a look at what Ferndale has done. I mean, Ferndale is a very liberal community, and that does affect how the judges are going to act.
Good point.
So,
well, let's get our good friend. I think we've got I'm guessing this is our caller from the northern part of the state, Eric Van Dussen. Eric, is that you?
Yes, it is. Can you hear me?
Thank you so much for calling in. For those of you that don't know Eric is a warrior advocate, amongst other things. He works with attorney Jesse Williams. Eric is, call him just Mr. Information, just constantly dispensing of all the important information, video reporter, and the list goes on and on. How have you been, Eric? Tell us what's going on with you and things in the northern part of the state.
Well, I just caught the last few minutes of your conversation, and I do know that up here in the 13th Circuit in the Grand Traverse County area, the district and circuit judges had basically a policy that no one could use while on probation in any other courts. And Jesse's butted heads with them on that numerous times. Other judges, such as Judge Botzer in the 19th Circuit in Benzie and Manistee County, has looked at it on a per-case basis, and he really hasn't come down hard one way for or against, but he's been open-minded about the issue. I think that with the Kuhn decision, though, reaffirming that the Medical Marijuana Act supersedes all other acts that are inconsistent with it, with the Supreme Court unanimously reaffirming that, it puts a real hindrance in front of these judges when they have a probation act that is in conflict with the Medical Marijuana Act, which is the Probation Act forces judges to prohibit probationers from using marijuana because it's in violation of federal law. And I think the Supreme Court resoundingly told the lower courts that that's not acceptable anymore for any act, including the Probation Act, which has that language that you can't violate any federal law in it.
We've argued that now a few times in a couple cases out of Komorn law, but also, I don't know.
Prior to Kuhn or post?
No, well, I've had many prior to, but obviously this is, I never, the greatness of the Kuhn opinion is its reliance upon the 7E, because that is such a powerful sentence, in the Act that has just been left out. It's the first time, right? It's the fourth Supreme Court opinion, and first time the law has relied upon that as the key principle by which to, offer its opinion. You know what I'm saying?
Yeah, well, defense attorneys have been arguing it since the law was enacted, and prosecutors and judges throughout the state, including the Court of Appeals, have basically just blanketly ignored that language, except for, in the 13th Circuit Court, that was one weird opinion because a conservative Judge Rogers, in that, he issued a great opinion in the Kuhn case in the Circuit Court, which was overturned by the Court of Appeals. So,
and of course, the good news was that they dismissed the case against Rodney Kuhn. Trouble after that, but
yeah, that's kind of sad. It's not looking good for him.
It's too bad about that. All right, so we were talking about what we've now described in a historical moment, and then we're calling the show the MMMA MMA 101 Part 1, and we've renamed it as the Renaissance Period, and we're talking about ballot initiative time frame until the first raids started happening at dispensaries. Rick Thompson of the Compassion Cause actually came up with that, but I'm taking it now. We'll share it, I guess. But the idea here is that it was definitely a different philosophy of what was going on. Aside from the legal disputes that may have been taking place with Jesse and other opponents, what do you recollect from that period of time? Where did you see things at the time? We talked about optimism, and was it that same way in your view? And where do you recall yourself, looking into this thing back in this period of time, 2009-ish?
Was that for me, Michael?
Yes, it was.
Okay. Well, what I've seen throughout this period is, let's look at the Kuhn case as an example. The Grand Traverse County prosecutor that argued that, the assistant prosecutor, Jennifer Tang Anderson, is a very nice, approachable woman, and she argued it very well in front of the Court of Appeals and got the case overturned. She is now the assistant prosecutor in my home county, Benzie County. She got hired on in Benzie County, and I talked to her about it the other day. And, I was kind of teasing her, but I was a little serious when I asked her, do you know what the impact of your argument and the Court of Appeals ruling had on, for the last year since that ruling has come out, the effect it has had on medical marijuana patients throughout the state that have been subjected to prosecution, arrest, and losing their driver's licenses. And then the Supreme Court comes out and unanimously overturns that and says it never should have been that way. And now there's all these people sitting out there with convictions. And, she wasn't cold-hearted about it, but, she's like, that's how the legal system works. There's an adversarial nature of it, but I think a lot of prosecutors and cops don't have heart, and she does. I can see that when I speak to her, but a lot of them just don't care. They're like, they think this is the worst decision in the world, that the Supreme Court actually is giving people rights that the Court of Appeals and the cops and prosecutors have taken away for the last 4 years. And that's what I've seen throughout the state in my investigations and my recordings in the Court of Appeals and the Supreme Court, and looking at all the cases that I've researched. It's really been a travesty on how it's like been like shooting fish in a barrel for law enforcement and prosecutors with medical marijuana patients who, for the most part, are honestly trying to comply with the law. But when cops get into their homes, most of these people just consent because they think they're doing the right thing, and then cops nitpick everything apart to the point where no one could possibly meet the standards that most of these officers require. So I think the tides are turning because of the succession of Supreme Court rulings that have kind of, put the Court of Appeals in their place.
By the way, you are listening to Planet Green Trees. We have 1 hour and 3 minutes left. Call number is 1-347-326-9626. Tonight's episode is called the MMMA 101 Part 1. We renamed it as the Renaissance Center. We're going to be doing a series of pieces, I would say, of the evolution of the Michigan Medical Marijuana Act in Michigan. We've got great studio guests in the studio here. Eric Van Dussen's on the line. I know we've got Jeff Hank on hold. Stay with us, Jeff. I want to get to you in a minute. But as we explore this one topic here, and we're talking about what we're calling the Renaissance period, really right after the initiative, which we read as one of the commandments, I would say. In order for you to really understand the Michigan Medical Marijuana, you have to be in touch with the ballot proposal. But this period of time, Eric, let's see. You were referring, of course, to the Kuhn case, which was a critical case in Michigan. And it's odd, your comments to me about how the prosecutor reacted. And maybe they just took it a little bit more personal because she was the one that argued it and was obviously overturned. Not just overturned, but unanimously 7-0. Maybe there's a little bitterness there. But to me, the prosecutors I've run into, like, oh, yeah, of course. They should have to prove impairment. It was unfair before. Like they don't want to, Like it's hard for them to, the law's so often in their favor for them to just kind of like, you can't abandon, there's no way to really fight a 7-0 opinion and suggest that it's wrong and still pretend to uphold the law. You know what I mean? Right. So you got to come up with some excuse.
It's kind of like talking out of both sides of their mouths because right. I don't see any of these prosecutors, pursuing justice right now for all the people that were wrongfully convicted throughout the state for the last year under the Court of Appeals precedent.
Look, I have not given up on the fact that there may be some retroactive ability to go back and address these. I do think that there's a possibility. And
I think court rulings on the MMA have to be retroactive because a lot of times the ruling comes well after the event that actually occurred.
They're interpretation rulings.
Well, I'm just saying, like, the Rudoi case.
Here's the thing.
4 years later, the Supreme Court ruling affected how their case was going to be handled. So that was retroactive.
That was future-active.
Because, we were making the argument, well, how were these people to know what the law was going to develop into? But we were losing those, and the court was saying, no, they're held up to the law at the standard it is at the time of the adjudication, which is retroactive to the incident itself.
Well, I think, listen,
the procedural problem is procedurally, how do you go about, setting aside someone's conviction or motion for a new trial when there's so much delay in your appellate rights have told your time limits? Do you file delayed applications for leave to appeal? I don't know.
No, you have to challenge it in the trial court. You got to find a legal theory to do that by. The motion to set aside a conviction, 6500 motion, is not available.
They're not not available.
Right, but you got to find some other theory. You got to find another theory based on, I think, due process or, I think even based on Section 7E. That's the key. I think the significance of this ruling in this capacity is more significant because of the analysis. You know what I mean? At the time this law went into effect, notice was given that any law that contradicts this law shall be trumped by the Michigan Medical Marijuana Act. Yet prosecutors continue to charge. What's the ruling? What's the unambiguous ruling? And when I say unambiguous, let me restate 7-0 as a unanimous opinion. Presence alone is not guilty. It's got to be presence plus some kind of behavior associated with being impaired or intoxicated, affected by the cannabis. Anyways, Eric, reflect a little bit on, your first memories of the things you recall, just even if it's anecdotally, even without just because it's silly, a lot of it, when we look back, like who would have ever thought that, there would not be a medical marijuana defense in court, which took place for 2 or 3 years, even though we're not there yet, but like preceding that and the time frame on the, on the map there, what's your recollection? Like what was going on in Traverse City area, for example?
Well, I think one thing to reflect on is the preposterous and selective enforcement of cops raiding hodgepodge all over the place, different dispensaries, and leaving other ones alone throughout the state, depending on what jurisdiction you are in and what police officers you might have irritated before in your life. It really had ramifications in some areas, and other people, nothing's happened to them. I mean, we've had dispensary cases, Jesse Williams has, in counties where one dispensary will get raided and they'll be prosecuted, another will get raided but not prosecuted, and then another one won't even ever get raided. And I don't understand. It's all the same drug narc squad that has jurisdiction over all of these territories where these different dispensaries are operating, but it's like they selectively enforce who they're going to go out and screw with on a daily basis. And, there's been no uniformity throughout the state, so no one, it's like the cops and the courts and the prosecutors expect all these lay people to understand the intricacies of the law throughout the last 4 years, and the penalty for them not understanding it is then possibly going to prison. But these cops and judges and prosecutors can't even agree and haven't agreed with the way the Supreme Court has ruled recently in a string of cases. So it's like they don't get penalized for being wrong. They have immunity from litigation. You can't sue them because they got it wrong and prosecuted you for 4 years, and then, I guess you were entitled to a Section 8 defense. I think that's been crazy for the last 4 years.
That's what I would have, in fairness, all of the original decisions should have gone to the defendants. They really should have, just to force the prosecutor's offices to be the one to publicly, foot the bill, or at least be the persons to decide. It wasn't that way. All of the burden financially was thrown on the patient community, and it's just. But here's one of the things I want to ask you. Got a couple like the beginning topics without getting too much into the original cases. Deal with the initiative, how it passed, what it said, observations of the first year. But the next topic was, I want to hear your thoughts on this. Then we're going to take a break and come back with our next guest, Jeff Hankin. I want you to stay on the air, Eric, if you would, to join the conversation with Jeff. But what were your observations or recollections about compassion clubs in and around your area? Do you remember them being...
As far, you mean just like compassion clubs that weren't deemed to be dispensaries, or just
right,
those type of operations?
The old school compassion club where they'd meet at the library, and.
Well, I didn't really go. I didn't really go to. I really didn't associate at a lot of those places. It wasn't my thing. It never has been. And I don't make a secret of the fact that I'm a medical marijuana patient, but I don't go out, I will go to some outings here and there, but I really just don't have the time to do a lot of that. So I really wasn't involved in those settings very much, but I do know that it was pretty robust in in one area, like Crema in downtown Traverse City, for probably close to a year, they had farmers markets like a couple times a week downtown Traverse City, and multiple people would set up booths, and it never. I don't know if the city ever got any complaints about it,
Right.
but I really don't have a lot of firsthand knowledge about the inner workings or how they were attended or anything like that.
Well, I was more or less pointing them out as they were kind of the, if I may, potentially as a pun, it was like a seed in a way that was the original kind of locations where, any kind of, even if it was educational and it wasn't being done, nothing else was being done public, it was a way for resources to be had and people to meet, at least publicly, and, it had to begin somewhere.
Learn the law and learn how to fill out the forms, even.
Right.
And actually, I think and Kevin Flamden and stuff, and those guys used to hold meetings at the library up in Traverse City. And I called in one time, and you were actually there filming that meeting. But I called in.
I think there was a Benzie County Compassion Club at one point as well.
There was.
Still there. I think it's still going. I don't know. Do you recall Jesse? Jesse, one of the things I did, we used to go to the compassion clubs and answer questions and, kind of.
Yeah, he's done some of that.
Yeah,
I think one thing that's been a little disheartening is, and Jesse and I were talking about this today, is that just like in high school, I don't ever remember one of my teachers ever teaching me my civil rights. Like I had the right to remain silent. I had the right to be free from unlawful searches and seizures. I was never taught that in high school. And when this law was enacted, there's all these people coming into it that were never, law enforcement gets trained on how to enforce laws, but citizens don't get trained. And a lot of them haven't even read the Medical Marijuana Act even 4 years after it was enacted. And I think that a lot of these medical marijuana patients that have had problems with the legal system could have avoided a lot of their problems by just simply reading the simplistic statute, the Medical Marijuana Act, because it's very easy to read, regardless of what some Court of Appeals judges have tried to mete it out for the last 4 years.
All right, listen, stay with us, Eric. We're going to take a quick break. I know we've got Jeff Hink on the line. He's going to talk about what's happening in Lansing, and I think we have our next guest on and in the queue after that from the Human Solution. We're going to take a quick break and be right back after that. Listen to Planet.